said we're ready, we're not ready. We're now ready.
Court rise in favour. It is a part heard appeal in the matter of WTGIL Ltd and the Commissioners for HMRC.
Yes, Mr. Mann.
Good morning, my lords. I propose to structure my submissions in this way. First to deal with non-monetary consideration, then monetary consideration, then the respondent's notice points. First is consideration, if there is any, capable of being expressed in monetary value, and then our argument on exemption of the relevant service. My submissions on non-monetary consideration will follow this pattern or something like it, I hope. First, responsive to my learned friend's submission, what is the role of contract in VAT? Second, looking at relevant agreements to highlight rights and obligations or the absence of obligations. And including in that, responding to the cases my learned friend relied upon on the approach to contractual construction. Then addressing cases on direct link. And lastly, addressing the errors in the Upper Tribunal reasoning that my learned friend has alleged. So dealing first with the role of contracts, there's a significant measure of agreement, but I think not complete agreement. We agree that one should look at the agreements entered into between the parties to identify the particular rights and obligations. And that includes the interpretation of the agreement. And the principles of interpretation of written agreements under English contract law apply and are generally well known. It's perhaps just worth reminding ourselves of a passage you've been taken to in Secret Hotels 2, where Lord Neuberger said that you have to look at the words, provisions of the agreement as a whole, surrounding circumstances known to the parties, and commercial common sense. And then obviously in the authorities bundle we have more cases in that area, which I'll come to. It's important, particularly in a case like this, where there are arrangements involving three key parties and beyond, that it's firmly established that for VAT purposes, where there's more than one agreement amongst different parties, for the VAT analysis, including who supplies what to whom, for what consideration, one must have regard to all the circumstances in which the transaction takes place. So the whole of the relationships between the various parties. And in performing the overall VAT analysis that's needed, one in our submission should be very cautious about saying that there is some improper mixing between the necessary English law approach to interpreting contracts and that way in which, for VAT purposes, one's told one must look at the whole of the relationships and ascertain the substance of each relationship in the context of the whole. And in our submission, when one comes to looking at whether a supply is for consideration or not, it is definitely the VAT test that we find in CJU cases. I always tend to refer to CJU in Tolsma, as the Upper Tribunal did in this case, which needs to be applied to see if there is consideration for VAT purposes. So one needs to look, as the Upper Tribunal and the First Tier Tribunal did, for reciprocity, mutuality of exchange and direct link. And very often there will be no tension at all between the approach that applies in ascertaining whether there's consideration as a matter of English law and ascertaining whether there's consideration for the purposes of VAT. But one does need to remind oneself that in terms of answering that VAT question, you're not concerned with whether there is a contract as a matter of English law. You don't need an enforceable English law contract in order to meet the requirements of consideration. You only need a legal relationship. What you do need is reciprocity and direct link, but because consideration in the Principal VAT Directive is a European law concept that cannot ultimately depend on whether the national contract law of a member state, or in this case, the position we're in now looking at events at the time we're looking at, the UK, national contract law finds there is consideration or not. And we submit, therefore, that in principle, the Upper Tribunal's approach must be right. Can I just take you to see paragraph 54 of the Upper Tribunal's decision? That's in the core bundle at page 94. Could I just invite you to read that paragraph, please? We submit that the approach that my learned friend took on behalf of Ingenie below and here is inapt, because we say it is or is predominantly a search to find consideration as a matter of English law for the provision of the device service referred to in part 1 of the policy booklet. May I use the phrase device service to refer to the service that's, and we accept it's the supply of the service as the tribunals below found, the supply of the service of providing and installing the device by, supplied by Ingenie to a policyholder. And we submit there's rather a narrow focus on first part of the policy booklet in my learned friend's English law contract analysis, which certainly isn't compatible with the right approach that you need to take at the end of the day to ascertain whether there's consideration for VAT purposes. I'll come back to this, but in many ways, the driver for the search for consideration, when one strips back what my learned friend is submitting, is the phrase which one finds in part 1 of the policy booklet at the very start. This contract is between the policyholder and Ingenie. And of course, there's reference in that part 1 to Ingenie installing or having installed the device in the policyholder's car. So, because it's described as a contract, one, it said, ought to find that there is a contract as a matter of English law. In order to find an English law contract, one must find consideration. And there must be, therefore, be consideration, because there has to be a contract as a matter of English law. And having found that consideration as a matter of English law, one must have VAT consideration. And one sees in a simple situation when one's looking at Amazon or a retailer on Amazon, which is offering to sell goods at a particular price, and a customer who's agreeing to purchase goods at that price, one sees easily the mutuality of exchange, and one, with respect, isn't probably going to be in the First Tribunal, let alone the Court of Appeal, arguing about any differences between consideration in English law and consideration in as a concept of VAT law. But we're not, and indeed we're very far from, that simple situation here. I don't want to suggest there's not something more to it than that, but can we just go and remind ourselves, if you would, of the first part of the policy booklet. That's in the core bundle at page 218. It's tab 13 for those using tabs. Two-1-8 is the page I want to go to, rather than the first page. So we see the statement at the very top of page 218. For this section only, the contract is between you and Ingenie Services Limited. And we then move on to look at what PB1 actually says about rights and obligations. And we say it's just a statement of what Ingenie will do after the policyholder enters into a contract of insurance with the insurer, who I'm probably going to call the underwriter, so we don't have too many I's floating around. So in 218, on the left-hand column, a device will be installed in the car. Also, Ingenie will arrange for a device to be fitted to the car. And if one turns over the page 219, about halfway down, Ingenie will aim to install your device within 10 days of your insurance policy commencing. That's just about the timing of the installation, and one can't infer any unilateral contract or any reciprocity for VAT purposes from that wording. So
is this an English law contract in your submission or not, or don't we need to decide?
Well, one, you don't need to decide. Secondly, in our submission, the tribunal and the Upper Tribunal didn't decide, and they didn't err in not deciding.
But as I understand it, it is necessary for there to be a legal relationship.
Yes.
What is the nature of that legal relationship if it's not a contractual relationship?
Well, I think the nature of the legal relationship between the policyholder and Ingenie arises when one looks at the whole scheme of the arrangements. So including the arrangements between the underwriter and Ingenie, and including the arrangements between the underwriter and the policyholder. So to...
What's legal about it if it doesn't involve any legal obligations?
Well, my lord, in our submission, it can be legal without having any enforceable obligations. That's clear from the case law of the CJEU, the town and county case. So there doesn't have to be an enforceable agreement. There's a relationship, a legal relationship we submit, sufficient for the purposes of establishing consideration for VAT because of the place that the first part of the policy booklet sits in relation to the other arrangements. And the tribunal was perfectly entitled to hold that that was a legal relationship without concluding that there was consideration as a matter of English law or of enforceability of rights under that agreement. It's clear that Ingenie is saying it's going to do something in the context of the overall arrangements. But the question really is that a promise which is being made so there's a mutual exchange of obligations? So, sorry, there's a mutual exchange linking the device service which is set out in the first part of that booklet and the entry into the contract of insurance by the policyholder.
If we, if we were simply considering an English law question, is Ingenie's statement that it will install and aim to do in 10 days an enforceable contractual promise? If that was the question.
That was the last part of your Lordship's question. I didn't get round to answering it, and thank you for the opportunity to do so. Again, having answered my Lord Justice Popplewell's question.
I mean, I understand.
We say, can I say three things? Yeah. One, no. Two, the answer is maybe difficult. And three, that's why the better approach is to look at the VAT concept of consideration precisely as the First Tier Tribunal and the Upper Tier Tribunal did.
Without going through the exercise of asking the question, I mean, this is clearly an English law relationship. It's clearly governed by English law. It's not governed by any other law. You say you don't need to go through the process of saying, is this actually an enforceable contract? You jump straight to, as a matter of VAT law, is the supply of the service, which we accept was supplied, for consideration within its EU meaning. Is that right?
I think one looks at the terms and obligations which one can see as a matter of English contract law, interpreting the agreements accordingly. But then one gets to the question of, in English law, I think, is there a unilateral contract here? So this being a situation in which there isn't a mutual exchange of promises, a promise and a counter-promise, is what the policyholder has done, entering into the contract of insurance, consideration as a matter of English law for the provision of the device service, as my learned friend says it is. And there may be situations in which it's relatively straightforward to see that as a matter of English law there is a unilateral contract made in that way. But here we say it's not straightforward. For one reason,
sorry, but just before you develop that,
yes.
So it's not straightforward, but is it your submission that if one were looking at it purely as a matter of English law, there is not a unilateral contract?
If you like, straitjacketed in that way, yes, there is not a unilateral contract.
Right. And you were going on to explain why.
Yes, without losing sight of why I say it's not, certainly not decisive of the EU VAT question, and therefore
no, and
why it's not vital to do it.
No, and I think you say it's inappropriate to do.
Yes, well,
as
yes.
my lord says, you simply look at it. You look at the VAT question.
But sorry, at some point you will need to explain then what's wrong with those cases we were shown yesterday, which say that the right way around to proceed in this type of case is first of all to look at the position under English law, and then you go on to apply that in the VAT, obviously with whatever necessary modifications, to fit it in with the EU, with the VAT law concepts.
Well,
and you seem to be saying we should ignore that first stage altogether and just plunge straight in at the VAT end of the swimming pool.
No.
No?
Not at all. I hope. I do think you need to look and look at the agreements and see what rights and obligations there are, and then, in this case, it's really working out whether there is a unilateral contract or not in my submission.
But using the word obligation presupposes an analysis, doesn't it, in contractual terms, pretty much? I mean, an obligation is something the law will compel you to do.
Well, yes, and then we do get back into the difficulty that in VAT terms you don't need an enforceable obligation in order for there to be a legal relationship, which again suggests that there's more to it than
But surely if you can find a legal obligation which is enforceable as a contract under English law, I mean, that's usually going to be 9/10 of the inquiry, isn't it? Well, of course, there are several cases where there's no intent to enter into legal relations, or maybe the consideration is deliberately chosen as purely nominal. You know, I can think of difficult cases, perhaps, but here we have a purely commercial bona fide, no hint of any special tax avoidance or anything of that kind, but a normal commercial relationship where you have one party saying in terms, this is a contract, and pursuant to that contract I'm going to supply this particular piece of kit as part of enabling you to take out a special kind of insurance policy. Why should we be overcomplicated about that?
Well, could we just look at again at what the contract, what part one of the booklet says?
Well, it says this contract.
Well, indeed. So, without beating about the bush too much, that's the label. So it's being labelled as a contract there. look at matters surrounding it in terms of labels, we know that what the position is in terms of both VAT analysis and English contractual interpretation, and it's aligned, and one can see it aligned in secret hotels too, that labels can never be decisive and often don't carry any weight. So because a document has a contract on the top of it, doesn't mean that it's a contract. And normally one would be looking for promises going both ways, a promise and a counter-promise. And you don't have that here. All you have...
I understand, sorry to interrupt,
Yes.
that as a matter of law, labels are not conclusive. So if you create something which in law is a lease, you don't get out of it, Rentax, by calling it a licence.
Yes.
Street and Manford and so on. The same
Yes.
applies for tax purposes. But this is slightly different because when somebody says, I will do something, and then says, this is a contract, and that's a document produced by a business for the benefit of a consumer, one might start with quite a strong presumption that that was intended to create an enforceable promise, because otherwise it's misleading the consumer. I mean, I don't think it's quite like a Street and Manford case. I think you do start with a presumption that if a business tells a consumer, we have a contract and I will do this, it would have to be quite unusual to conclude that there was no enforceable promise, wouldn't it?
Well, my lord,
It's not as if a label is to be thrown away as of no importance.
no, my lord, but I think one would look at what is set down in the agreement, and one would look to see what is said is going to be done by the commercial party, and see if it's said that the consumer has to do anything in return.
Right.
And it's not said that the consumer has to do anything in return. These, I think, are probably more minor points, but if you'll allow me to make them, we've seen from the website journey that when you are about to agree to accept the quotation, you're offered the opportunity to follow a link which says view the policy wording. That's the link that you follow to the policy booklet 1. It doesn't say the policy wording in a contract between the policyholder and Ingenie, but it does refer to the TOBA, the contract between Ingenie and the other contract between, or the contract between the policyholder and Ingenie at another point. If we just look at the contents page, on page 217, we have for pages 3 to 4, which is said to embody the contract between Ingenie and between Ingenie and the policyholder. It's just described as introduction to Ingenie. So is the top of the page. In contrast, in the index, the contract of insurance is referred to as such. And of course, we know if you turn over to page 220, the next section of the policy booklet is headed Contract of Insurance. And a point that I'm going to make, and I may take you to the authorities, for a unilateral contract we submit, you would normally see something very plain. If you walk to York, I will pay you £100. But this isn't presented as an if-you type of arrangement. It's simply a recitation of what Ingenie will do that may or will benefit the policyholder after the policyholder has entered into the contract of insurance.
Doesn't that make it dependent upon entering into the contract of insurance? How is that different from if it actually said if you or when you enter into the contract of insurance. I mean, that is necessarily implicit in we're going to fit this within a certain period after you've entered into the contract of insurance, and it would be blindingly obvious, wouldn't it, to the potential policyholder from the arrangements that they wouldn't come and fit the box unless and until they'd taken out the insurance.
But well, that's on the basis of an argument which my learned friend did run below, and I believe runs here, that the two parts of the policy booklet are indissociable. They're inextricably joined together, and that therefore it's inevitable if the policyholder enters into the contract of insurance that it will get the benefit of Ingenie Services. But the point is, when one looks at the relationships as a whole, one sees that there is no need for the policyholder to have a unilateral contract with Ingenie, because there are promises to him by the insurer, which relevantly here includes the provision of the device service. So in my submission, it's not the inevitability on the basis of which, as a matter of English contract law, one can or should infer that entering into the contract of insurance by the policyholder is consideration for what it's stated Ingenie will do in Part 1 of the policy booklet, including in particular the providing of the device service. This is an introduction to Ingenie. It's just explaining what Ingenie's role will be in relation to the contract of insurance in our submission.
So, have I understood it correctly? The gist of your submission is that the policy terms that apply between insurer and policyholder include a promise by the insurer that the device will be installed.
Yes.
And this section is simply identifying that it's Ingenie who are going to be doing it. Is that the gist of it?
It's giving more detail of the means of which it's going to be done. It's introducing Ingenie, but yes, and we can see the arrangements overall. If we go to staying in the same divider of the same bundle, page 227. This is the contract of insurance.
Yes.
On the right-hand page, the selected installer will fit the Ingenie device at a mutually convenient time. So that raises questions, we say, both in terms of English contract law, but even more particularly in terms of VAT law, whether the necessary mutual exchange and reciprocity is in place in relation to the device service described in Part 1 of the policy booklet, and entering into, not the promise to enter into, we're all agreed there's no promise to enter into, wouldn't make sense to talk of a promise to enter into, so at no time is the policyholder obliged to enter into the contract of insurance. And he knows from page 227 that when he does, as part of his insurance policy, because the insurance policy will only work for the policyholder or the insurer if there's a telematics device, the device fitted, that he's going to get the device fitted. And the insurer is going to be responsible for it.
And how does that argument apply to what we've got at 218 in relation to providing feedback from the app? Is that anything that's covered at all at 227 or elsewhere
No.
in the insurance policy?
No, the insurance policy doesn't include a promise to provide any feedback to the policyholder, other than in circumstances where I think they've got a black warning.
So that part of part one of the booklet isn't a statement of the of obligation of the insurers. It's a statement of something that Ingenie will do, to put it in neutral terms. Whether you call that a promise or let alone an enforceable promise, it's a statement of something that Ingenie will do, which isn't to be found elsewhere.
That's correct, my lord. Yes, but we are concerned when it comes to the question for VAT consideration. Is there a direct link between the device service?
Well, I know we are, but at the moment we're trying to work out, as a matter of English law, what the status is of the statements that we're getting in part one.
Yes.
And the statements include that there will be an app from which the punter will receive feedback. Is that statement contractual?
Well, my lord, I say it isn't. I say it doesn't matter to the that analysis if it is.
But I mean, this is an outward-facing consumer document. And I guess the elephant in the room, the real problem is just the first two lines, isn't it? It just says, in terms, this contract is between you and ISL. I mean, what could be simpler or more unambiguous than that? It's a contract, and the two parties to the contract are the would-be policyholder, if he hasn't already entered into it, and ISL. And it then goes on to explain why ISL is involved in what would normally be a straightforward bipartite contract between the insurer and insured. Here we have this special type of insurance which involves provision by a third-party ISL of this particular piece of kit which is going to be fitted and will enable the policyholder to get the benefits, if they truly are benefits, of this particular kind of insurance. But on any view, this is a contractual statement, isn't it? Or it's intensely misleading if it isn't intended to be. Because this is about the first thing which the policyholder is going to read.
Well, my lord, in our opinion, it doesn't make it necessary for you to conclude that there is a unilateral contract in which the policyholder is entering into the contract of insurance in return for this. It certainly doesn't require that in relation to the device service, which I know is a VAT point rather than a contract point. In our submission, that if that is the right answer as a matter of English contract law, it can't be the decisive answer in relation to the VAT analysis.
Well, I'm entirely with you on that. It's just the first step in the analysis, though, is to work out what the English law position is. And that seems to be what I've forgotten which case it was, where the Supreme Court, Lord Newberger, was saying...
Secret Hotel.
Thank you, Secret Hotels, saying that is the right order in which to address this kind of question. So there's no mystery about it, and there's no reason why... I mean, sometimes something which is stated in black and white and means what it says. Really answers the question, is there a contract? Okay, well, we can get that little bit of the inquiry out of the way. Yes, there is a contract, because the parties agreed there was. And said so.
Well, My Lord, I think you have my submissions on that. In terms of the VAT analysis, it's clearly important to look at the relationships as a whole, and so I've.
Sorry, just before we leave that, suppose that the policyholder takes out a policy and is waiting and not getting the black box installed, and says to Ingenie, come on please, you've got to install it. You said you would in this section of the policy. If you're right, Ingenie could say, no, we're not under any obligation to do so. You'll have to take that up with the insurers. All right?
Yes, my Lord.
Oh, is that what the policyholder would think it was getting? And is that what Ingenie thought it was telling the policyholder? I think that would come as a surprise to both of them, wouldn't it?
Well, my Lord.
Perhaps it wouldn't, but that's how it strikes me at the moment.
It's certainly the case that the policyholder is concerned with taking out insurance and concerned with what it's going to get from the insurer, and it does have the promise from the insurer, and the promise from the insurer is enough, and Ingenie is acting as an insurance intermediary for the insurers, for the underwriters. So in practical terms, you're going to be picking up the phone to Ingenie, I think, anyway, to try and get it sorted out. And it's going to be sorted out in that fashion.
Well, it may be in the real world that the policyholders don't really understand the distinction between Ingenie and the underwriters at all, especially since this policy booklet is branded as the Ingenie policy. I understand that, but we do have to analyse it, don't we, in terms of the legal relationships on the footing that the documents are seen and read and mean what they say.
Yes, I accept that. You shouldn't decide the case on the basis that policyholders, potential policyholders, just don't read the documents. I think I accept that.
I mean, the likelihood may very well be that they never click on this, and if they are sent it, they never read it. But that's not the basis on which we can proceed.
No, my Lord. What I wanted to do next was just to draw out distinctions for VAT purposes between the unilateral contract cases that my learned friend has taken you to and the facts of the present case. So could I invite you to turn to the authorities body of the PDF. And first, the Thornton case. At tab 16, page 316. Forgive me. So the first point at paragraph 5, and I realise this may not impress your lordships in terms of the English law contractual analysis, you'll just see the clear way in which the offer was made by Thorn. It's about 5 lines down. To benefit from this offer, all you would have to do is sign a 12-month rental agreement with Vodafone Local. And this was a case in which Radio Rental's customer got a phone in return for entering into that unilateral agreement that followed from that offer with Vodafone. Thorn was paid by Vodafone for introducing the customer to Vodafone and getting him to enter into the contract. There was, however, no question of the supply of a phone by Thorn to Vodafone. The only supply was of the phone by Thorn to the Radio Rentals customer. And if I could just take you to Empire Stores, sorry, I'm doing this a little bit the wrong way around, and then tell you the points that I want to get out of them. Empire Stores is in tab 17. And you'll see a description of the unilateral contract in the, or a description of the scheme on page 333 at paragraph 4. I just invite you to read that.
I'm so sorry, give me that reference again.
Page 333.
So this is in the judgment, not the outcome.
In the judgment, yes. So goods are provided by Empire Stores to a customer or to somebody who introduces a customer. Is offered goods in return for giving the customer certain specified details of themselves or of the new customer they're introducing. And again, it may not impress your lordships, but the clarity in which it's clear that one is in return for the other in the leaflet documents. And we'd say, again, there's supply is a provision of the gift by Empire Stores to the customer or to the introducer. There's no question of the gift being supplied by Empire to anyone else. So the first point I wanted to make, and I will make it, that there's obviously in these VAT cases where there's a unilateral contract, there is an express offer. If you will do A, we will give you B. The recipient of the supply of goods then does A. So it's not a difficult case in terms of we submit contract law or unlike what we say the situation is here. And also, in neither case is there a supply of the relevant goods, and the equivalent here would be of the device service by the supplier to anyone else in the related arrangements. So there's no parallel to the situation here, where the device service is certainly being supplied to the underwriter. There's a tripartite situation in Thorn. There's not even a tripartite situation in the first example in Empire Stores. There is a tripartite situation, but a difference, which we say is economically significant in terms of economic reality. And so for the VAT analysis between those cases and these is that when one is looking in terms of a direct link and mutual exchange and reciprocity, in those cases there is only one supply being made by the supplier, whereas in this case there is certainly a supply being made by Ingenie to the underwriter of the device service.
Do you mean as well as the supply to the policyholder, or that the device service is only supplied to the underwriter?
Well, in VAT terms, I have to be careful how I respond to that, because the tribunal's held that there is, for VAT terms, if you ignore the requirement for a supply to be for consideration, a supply from Ingenie to the policyholder.
And you don't challenge that?
We don't challenge that.
So the distinguishing feature that you identify between this case and Thorn and Empire Stores is that in those cases the supply was only to the customer, whereas in this case the supply is both to the customer and to somebody else.
Yes, and in this case there is no doubt that there is consideration for the supply of the device by Ingenie to the underwriter. So that was important for the First Tier Tribunal and the Upper Tribunal.
Did they find that the device was supplied by Ingenie to the underwriters?
Yes.
Yes.
I don't think they find that the underwriters supplied the device to the policyholder. They just find that there was a policy of insurance as between the policyholder and the underwriter. And I've taken you, and indeed your lordship, you averted to the wording in that part of the policy booklet, which in our submission shows that there is an obligation on the underwriter as part of the provision of insurance to provide the device, would have the device provided.
But I think it follows from your answer that the findings of the tribunals, which are not challenged in this court, is that the device is supplied both by Ingenie to the policyholder and by Ingenie to the underwriter. Is that right?
Yes, ma'am.
Yes.
Or the device services.
Or the device service.
Yes.
I'm sorry.
Sorry, I lapsed out of the shorthand for the device service, I guess.
Yes.
Yeah.
Sorry, I'm not sure I got this down right. So it's common ground and found that the device, sorry, that the ISL supplied, that's right, the device services, what, both
Both to
the insurer and to the
policyholder.
And to the policyholder. Thank you.
I'm so sorry. I don't want to interrupt, but it's only my lord said it's common ground and it's found. It's not common ground. We don't agree that was a finding in relation of the device services to the underwriter. I'm sorry to interrupt. I'll deal with that later, but it's only because your lordship mentioned it being common ground.
Well, let me take you to the core bundle. And at least we can see the contractual obligation. It's tab 14, clause 4.4. On page 284. And you'll see there, Ingenie shall install or procure that a sub-agent installs a telematic device into the vehicle of each new insured in such manner as the parties may agree in writing. So there's clearly a contractual obligation owed to the underwriter in respect of the device service.
Yes, but
And
that's,
we know there's consideration for that in the commission.
that's not quite the
That's
same as
paid.
saying the device service is provided to the insurers. That's all that shows is that the device service was provided to the policyholder in fulfilment of a contractual obligation to do so owed to the insurers. But you're going to show us where the Upper Tribunal said it was a service provided to the underwriter, are you? Because I think you told us that if it wasn't common ground, that was at least what had been held by the tribunal.
My lord,
Or had I misunderstood what you were submitting?
if your lordship will bear with me for a moment. Well, that was my recollection, my lord. I'm very sorry I can't lay my hands on it at the moment. In my submission, it clearly is the right analysis, because it's clear that direct benefit is coming to the insurer from the installation of the device. The insurer needs the device installed in the insured's car in order to receive the data or the analysis of the data, in order that it can offer this type of insurance and can fix the premiums and review them from time to time. And that's clearly in our submission enough direct benefit for it to be applied for VAT purposes to the by Ingenie to the underwriter.
Thank you.
We'll try and find that for you.
Does it matter? I mean, as I understand it, it's not disputed that ISL did provide the device service to the policyholder. The only relevant question is whether that was, in EU terms, a supply for consideration.
Yes.
So what we are necessarily focused on is, did the policyholder provide anything in return for getting the box fitted? And just as it's in the interest of the underwriter to have the box fitted, because that's what the policy requires, it's in the interest of the policyholder to have the box fitted, because that's what the policy requires. So, do we need to concern ourselves with whether clause 4.4 of the terms of business between ISL and the underwriter mean that when the box is fitted, it's for VAT purposes a supply of a service to the underwriter or not? Because we know it is a supply of service to the policyholder.
Yes, we do know that it's a supply of service for the policyholder, but we don't know that it's something the policyholder is prepared to pay for, because he hasn't agreed to pay for it. And there is reason for him to enter into the contract of insurance with the underwriter, because he wants the contract of insurance. He wants the insurance to fragment the picture and say that he wants the device in my submission is not the correct approach, not the correct VAT approach, because what the policyholder is interested in VAT terms is getting his supply of insurance. He has no interest in the device aside from that. So
No,
there's good reason.
His only interest in getting the box fitted is so he can have the insurance, and hopefully, because he thinks he's a better driver than most people, he will be able to reduce his premiums, because the box will show what a wonderful driver he is. That's what's sold to him. You have the opportunity to reduce your premiums by driving well. So he wants all that. Now, that's obviously all part of buying the insurance, but he does want the box fitted. If he takes out the insurance, he wants to have the box fitted. So what's wrong with the analysis which says somebody is promising me that if I take out this policy, I can have the box fitted?
Well, in my submission, he doesn't want to have the box fitted in this sense. He certainly doesn't want to have the box fitted, I'm not think your lordship is suggesting this, in any way independently from the supply of insurance. The box is of no value or benefit to him at all outside the supply of insurance. And yes, he does want this policy of insurance, and he does want because it's a characteristic of this policy of insurance, the ability for his better driving to be monitored and reflected in a reduced cost of the insurance. But it comes back to he's entered into an agreement with the insurer where the insurer has agreed that this box is under an obligation to ensure that the box is fitted to the policyholder's car. So there's no need or reason, in the sense your lordship's explaining, for the policyholder to want the box in a way which means, objectively analysed, he's prepared to give further consideration other than the insurance premium that he's already paid. He's paying the insurance premium. He doesn't expect to have to provide any further consideration to anyone. And if one says, well, really doesn't matter to him because he's whether he's you link the provision of the of the device service to entering into the contract, because he's going to enter into the contract anyway. In our submission, in the VAT analysis, that sort of inevitability doesn't work. It can't generate a reciprocity or mutuality of exchange. When someone is inevitably going to do, if we're talking about this at all, if he doesn't take out a policy, or she doesn't take out a policy of insurance, this is never going to arise. But when one has taken out a policy of insurance, then one needs to, as we say, the Upper Tribunal and First Tier Tribunal did, look at the objective purpose of that. And you can't find that in our submission, that the objective purpose is to give something in return for the supply of the device service by Ingenie. In commercial and economically realistic terms, we say the customer simply doesn't require that device service to be provided to it by anybody else. The insurer is going to ensure that it's provided to it. And there's no reason to conclude that it has, in economically and commercially realistic terms, entered into the policy of insurance in order to get the device service. The device service is something it's getting under the policy of insurance.
Leave aside the question as to who it's addressed to be in return for. So I haven't expressed that very well, but the point of this is that it's aimed at young drivers. If they don't take out a policy here, they want to drive, they'll take out a policy elsewhere. And what makes this attractive to young drivers is it enables them to get insurance more cheaply than they would be able to elsewhere, or possibly when they wouldn't be able to get any insurance elsewhere. And the device is an integral ingredient, isn't it, of the ability of the insurers to offer insurance to them more cheaply, because it offers them A, the opportunity to increase premiums by reference to driving record, and B, to monitor theft and to monitor driving and to investigate accidents and so on. So the device is something that the driver has to accept as a necessary part of being able to get this cheaper insurance, and that's in return for agreeing to have the black box supplied by somebody. And then one gets the question, by whom? But it is an integral part of the insurance, isn't it? From the policyholder's point of view.
I think that's right, my lord. It's certainly an integral part of the insurance from the underwriter's point of view. And clearly, the policyholder isn't going to be able to receive a supply of that type of insurance without having the device installed in his car. But in my submission, that doesn't answer the question of whether there is reciprocity and mutual exchange, as my learned friend contends, between the device service supplied by Ingenie and the entry into the contract of insurance by the policy holder. Because
no, but it might answer the question as to whether there is reciprocity between entering into the contract of insurance and the box being supplied by somebody. Then one gets to the question of whether there's the reciprocity for the supply by Ingenie, or whether it's reciprocity for supply pursuant to, as you would say, the insurer's obligations under the policy to have it installed.
And we say, as the Upper Tribunal and First Tier Tribunal found, that's where the reciprocity is. The premium is paid by the customer for the insurance service, integral to which is having the device installed into his car. That's dealt with under the policy of insurance.
Thank you.
And just picking up in my notes, I want to do this, so I think I'm going to deal with it very briefly and not take you to the cases, if that's all right. So I said I would deal with the cases on the approach to contract construction or formation that my learned friend took you to yesterday. The first was the BAA case in your authorities bundle at divided 10, page 245. And we say essentially that doesn't give you any further assistance. It's in effect being overtaken by Secret Hotels 2 and the case law that we referred to in Secret Hotels 2. And the essence of what was being said by the Court of Appeal in BAA was that the VAT question was to be determined as a matter of substance and reality, which is then taken further by saying that you look at the substance of agreement, not the form or the language. Well, it's certainly right that you look for the substance. It can't have been in our submission the Court of Appeal was saying when you don't look at the language, that you don't look at the words of the contract, but probably saying you don't just look at the words as words. So it's not particularly out of alignment with Secret Hotels 2, but it doesn't take matters any further. And Craft Counsel relies, where a friend relies on, Craft Counsel is divider 22, page 437. And again, my learned friend relies on that Upper Tribunal case as an example of applying English contract law to imply terms into a contract. It's got no close resemblance on the facts here. And if your lordships feel it would help to look at it, I'm not suggesting we do it now. At paragraph 35, you'll see the Upper Tribunal's approach. And at paragraph 38, through a series of sub-paragraphs, A to E, you'll see that what the Tribunal does is look carefully at various clauses in the contract. And in our submission, it's of no assistance to my learned friend here, because what the Tribunal finds is that the obligation to hold a show on the part of the supplier was present in the express terms. It's not really a case of implying terms at all, but it's so far away from the facts of this case, it's not really of assistance. It doesn't stand for any particular principle, and it doesn't add anything to the VAT analysis. Likewise, I was going to submit that open work is a case dealing with whether contractual provisions are void for uncertainty. So in that case was no doubt that there was a written contract, and the question was whether a term was void for uncertainty. And the court said, unsurprisingly, that it would strive to give meaning to the terms, but it really doesn't help there. So far as Charnock and Liverpool is concerned, which is in the bundle at authorities 151, in our submission, that's a case about whether contract could be inferred between a garage owner and the owner of a car who was bringing in his car to be repaired. The court found, and therefore it established as a matter of principle, that a contract could be inferred in those circumstances, but it was inferred on particular facts, and the consideration was not entering into a contract. The consideration was simply bringing and handing over one's car to the garage, in return for which there was held. That was a consideration for service of supplying, in English law, repair services to the owner.
Well, I think the repair services were supplied to the insurer. That was the point. The repair contract was between the garage and the insurer. But you wanted to find a contract between the car owner and the garage, which was not a contract of repair. It was a contract with I will leave you the car so that you can do the work which the insurer is going to pay for. It's not. I'm not sure it matters, but maybe I've misread it.
No. I think my submission on that is that there were two contracts.
There's two contracts. There's a contract between the car owner and the garage, which is the contract sued on, because the car owner wanted to rely on an implied term that work would be done within a reasonable period.
I think there is a contract between the insurer and the repairer, that the repairer is going to carry out the repairs in return for payment by the insurer. I think that's right. But the exchange between the garage and the car owner is what we've identified what the car owner brings, but for those implied terms to be implied into the service must be one of repair, I think.
Right.
That's my submission.
But your essential point is that was simply a case in which they found there was a contract by conduct on the particular facts of those circumstances, and that doesn't really translate to anything that we're concerned with here.
Yes, I think really from some of the exchanges between your lordships and me this morning, I can see you're focusing quite directly on the particular scenario that we're dealing with, and the particular wording, indeed, in part one of the policy booklet in context.
This has slightly prompted me to make a point which I was going to make at some stage. We've been focusing, as Ms McCarthy did, on the entry into the policy being the consideration in English law for ISL's promise to fit the box. That's the way in which it's primarily put. But she has alternative cases that the consideration from the policyholder given to ISL is simply permitting ISL to fit the box in his car, his or her car, which obviously you're not obliged to do, but unless you do that, you can't have the policy. Why is that not non-monetary consideration? If you just had a separate standalone contract between ISL and the policyholder, ISL says we'll fit the box, and the policyholder says I will make my car available and allow you to fit the box. Now that has mutual benefits because it enables the policy to be taken out and everybody gets the benefit of the policy. But what's wrong with that analysis? Clearly, the policyholder does have to permit ISL to install a box in his or her car.
In our submission, that's as a result of entering into the contract of insurance with the underwriter. So there are obligations on the policyholder to have the box fitted. So he's not giving anything more or separate to Ingenie. and it's obviously not going to be the underwriter itself that fits the box. So it's the underwriter by an installer. And in our submission, when you're looking at it in the contract, in the context of these multi-party arrangements, and particularly in terms of VAT consideration, that is significant.
Okay, thank you. So the answer is yes, the policyholder does agree to allow the box to be fitted, but he's agreed, by taking out the policy, he's agreed that that should happen.
Yes. And that gets us, Manuels, I think, to my third point, which is looking at the cases on direct link. The jurisprudence of the CAGU is definitely in our submission what sits in the lead here. And you have the direct link test stated and restated by the Court of Justice of the European Union. And I, as with many courts and tribunals, and as the Upper Tribunal did, generally look to the case of Tolsma to find a helpful statement, because that's been repeated since Tolsma many, many times. If we could look at the authorities bundle, tab 14, page 303. Sorry, it's paragraph 13 actually starts on page 302. Could I just ask you to read pages 13 and 14, sorry, paragraphs 13 and 14. And you get from that a statement of the direct linked concept, the direct link concept, and the significance of reciprocal performance and mutual exchange, which are phrases you see used in the Upper Tribunal's judgment and its critical reasoning. Next, my friend took you to Empire Stores, and we certainly accept that there can be consideration for VAT purposes in the context of a unilateral contract. And I've explained the differences and distinctions between Empire and indeed Thorn earlier in my submissions to you this morning. And in our submission, at no point did the First Tier Tribunal or the Upper Tribunal err by concluding that for VAT purposes, if there was a unilateral contract, there couldn't be consideration. What they concentrated on in critical parts of their decision was the VAT test. Finland I can deal with very shortly. The paragraphs my learned friend referred to originally might have very reasonably been seen to add something to the direct link for consideration test if they had actually been talking about the direct link for consideration test, but they've gone. My learned friends replaced them with the paragraphs which do address the direct link for consideration test, but they simply don't advance matters. They don't tell you anything that you didn't already know from Tolsma, for example. The San Domenico case, sorry, I don't know whether I was being a bit nerdish in mentioning it. I don't need to take you to it. It says exactly the same as Gemeinde A, paragraph 36 in Gemeinde A that your lordship has referred to and that my learned friend took you to. It's just that's a post-IP completion case day, so you could choose not to follow that without going through the laborious process of applying the 1966 practice statement, whereas San Domenico binds you unless you would choose to depart from it in that way. It doesn't add anything to the substance. And Gemeinde A is perhaps worth looking at just again to remind ourselves of paragraph 36. In tab 27, paragraph 36 is on page 547.
So sorry, which paragraph?
36.
Thank you.
I mean, I can read it to you. In that regard, it follows from the court's case law that there's a direct link where two services are mutually dependent on each other. That's to say that one is made on condition that the other is also made, and vice versa. And that's a useful little addition in terms of understanding the direct link concept, reciprocity of performance, and mutual exchange. And that's, of course, what HMRC have submitted, and submit is missing here, and what the First Tier Tribunal and the Upper Tribunal found was missing here. And just to say, my learned friend made the point that in some cases, there's plainly going to be a making of a payment by the putative recipient of the supply, the putative supplier. So subsidy and grants cases, there's no doubt that money is going one way in those cases. And the question is there whether there's a direct link between that payment and the services that are being provided by the recipient of that payment. And that does obviously involve questions of looking at what benefit is being received and whether that benefit received is different from benefits that others who aren't making the payment are getting. But in our submission, that doesn't cause any confusion. It doesn't mean that there is a separate and different direct link test, reciprocity test across different scenarios. And it didn't, in our respectful submission, confuse the First Tier Tribunal or the Upper Tribunal. Can I just then, having shown you Gemeinde A, just go back to my learned friend's skeleton and a paragraph we focused on briefly yesterday, which is core bundle, page 44, paragraph 47. Could I just ask you to read that to yourselves again when you have it? paragraph 47 in my learned friend's letter. And this is dealing, I think, both with the sort of contractual test and the for consideration and the VAT test. And my learned friend said yesterday that one only needed A and one didn't need B. So the only requirement was if and only if the policy holder entered into the insurance contract did ISL supply the provision, fitting and use of the device. And in our submission, that's wrong on the English contract analysis, but far more importantly, it's wrong on the VAT analysis, because that's basically says if something has happened, then and only then is ISL going to do something, in this case provide the device service. But that cannot meet the requirements in our submission. I say cannot conscious that I'm saying it's impossible, of reciprocity of performance and mutuality of obligation. It's just somebody doing something when something has happened. And that was the way in which my learned friend rested putting her case on direct link yesterday. And that just can't be right in our submission. And if one adds in B, if and only if Ingenie agreed to supply the provision, fitting and use of the device, did the policyholder enter into the contract. We say, as you know, and I'm not going to rehash it, not the situation here as the First Tier Tribunal held on the evidence that causation wasn't proved by the appellant. But again, that's just if this thing happens, then this thing happens. But B also looks like a bilateral promise. If I promise to do this, you promise to enter into the contract. Even if I'm wrong about that, it's just a happening. So for VAT purposes, just because one thing happens and then another thing happens cannot meet the direct link, mutual exchange, reciprocity of performance test. And that's important here in our submission. And then, unless your Lordship have any questions for me further on the CGU case law on direct link, I was going to move on to the areas of law alleged against the Upper Tribunal. So that means having out the Upper Tribunal's decision. I'm going to start where my learned friend did with paragraph 81 on page 101. Sorry, I have mine loose. Do you know it is without a divider reference?
So I'm just tidying up. I've got mine loose as well.
Yep.
Sorry, as we've got it open, could we go to paragraph 101 first? I'm sorry, my lords, if you just bear with me for a moment. So I'm very grateful for those behind me, because they've found the passage in the Upper Tribunal that I was thinking of when I said the Upper Tribunal recognised that it supplies corporate advice to the underwriter. So in paragraph 101, it's about 8 lines down. The line starts with the case from, and halfway through that line you'll see a sentence beginning, it is also because.
Yeah.
It is also because the suppliers are in relation to the device, which is said by ISL to be made to policyholders for consideration, or in all material respects, suppliers which ISL already contracts to make the insurer under the Convia business agreement.
Well, that doesn't quite meet the point that I was putting to you.
Well,
That's not a finding that the device service was supplied to the insurer. It's a finding that it was supplied to the policyholder pursuant to an obligation to do so owed by ISL to the insurer.
Well,
It's not the same thing, is it?
well, my submission is that the tribunal there is talking in terms of VAT supply, and it's obviously talking in terms of supply where there's mutuality of exchange. But I don't think I can carry it any further than that. I'm pretty sure that was the passage that I was thinking of. So it's either I'm right about that or I'm wrong about that. If I can find something elsewhere that shows that my reading of it is backs up my reading of it relates to a VAT supply, I'll obviously let your lordships know.
Thank you.
So it's back to paragraph 81, please. And you'll see there that the Upper Tribunal says that it's concluded that the FTT hadn't made an error of law. And I think when we're talking about the VAT analysis, because it is a matter which depends both on contractual construction and on economic reality, one can't just treat it as a pure matter of law. I know many courts don't find it helpful to get into discussions, particularly at this point of appeal, perhaps, about what's pure matter of law and what isn't. But in our submission, there was no fundamental error in the approach of the Upper Tribunal in considering whether the First Tier Tribunal reached conclusions on the evidence which it was entitled to. That is not an error on the part of the Upper Tribunal. If the Upper Tribunal has failed to spot some error of law because there's been an error of law made by the tribunal in its contractual analysis, that's a different matter, because then there would be an error of law in the analysis. But if, as we submit is the case here, there is nothing in the contractual analysis which means that the FTT's overall analysis is wrong, then the FTT's and the Upper Tribunal's analysis stands. There's no relevant criticism of paragraphs 82 to 84. Of course, we're starting here because 81 is really where the tribunal, Upper Tribunal's come to its conclusion. It's now it's giving its reasoning. There's some suggestion at paragraph 84, I'm paraphrasing, that rather random phrases have been quoted from the Advocate General in Tolsma. But if you see stipulated exchange of mutually dependent services, stipulation of price for consideration, and for contractual exchange, that's all in our submission standard reciprocity of performance mutual exchange language, with the possible exception of stipulated. But in our submission, stipulated doesn't mean there has to be written down. It does mean has to be agreed, but it's not a suggestion that in terms of obligations there can never be an implied obligation relevant to the VAT question of whether there's a supply for consideration. So that's neither wrong nor problematic in our submission. And of course, I haven't said, you have my skeleton argument on the non-monetary consideration issue and the other issues, and I haven't read it out to you. Like my learned friend, I'm just going to refer you here to my skeleton argument on that. I don't need to highlight the paragraphs, they're obvious. In paragraph 85, my learned friend says what was said by the Upper Tribunal in the South African Tourist Board case is not wrong. That's why I haven't gone at length to the South African Tourist Board case. My learned friend does that for you, but it said, I think, that certain phrases have been highlighted and the case has been taken rather out of context. But if I can start with the second highlighted phrase on page 102. What the Upper Tribunal observed in SATB was the linkage is not one of mutual exchange of supply and consideration for that supply. So that's something perfectly standard and quite appropriate to highlight in this case. Back on the earlier page, the phrase falls far short of demonstrating the degree and nature of reciprocity required. Our submission that the Tribunal was just highlighting there, in an English case, both the reciprocity requirement and the mutual exchange. And it wasn't suggesting, and you don't find this in our submission followed through anywhere else in the decision, some particularly high standard for reciprocity of performance or mutuality of exchange. And in paragraph 86, the Upper Tribunal, in our case, did recognise that it was very different facts. There's no disagreement with my learned friend over paragraph 87, and my learned friend suggests that perhaps this is overcomplicating it in this approach, but we submit it isn't. Certainly there's nothing here which can be seen to be a springboard to error or to inevitable error. And in paragraph 89, of course, it's accepted by my learned friend that that is the critical question. And we also can remind ourselves, without necessarily taking you there, that the Upper Tribunal up to this point had properly directed itself. We say see the preceding paragraphs and see also paragraph 72, where the Upper Tribunal set out the 5 relevant criteria. And it's paragraph 91, which my learned friend says has several flaws, several errors of law. And I'm sure her submission goes so far as really to be that the Upper Tribunal decision can't survive the errors in this paragraph. Could I just take you to the end of paragraph 91 first? It's on page 103. Could I just ask you to read from the end of the first line to the conclusion of the paragraph? may need to come back and look at that, but it's certainly the Upper Tribunal reaching a conclusion that the First Tier Tribunal hadn't erred, and that the First Tier Tribunal had gone on and considered more, and that was more to consider before reaching a conclusion on the VAT consideration issue. My learned friend says...
But just pausing there, that again, doesn't it, betrays that the Upper Tribunal were looking at it by using the language of bilateral agreements as a reference to stipulating or referring to the agreements which were given by policyholder, not the actions, not the performance as the consideration, but some agreement given by the policyholder, which is a bilateral contract analysis, not a unilateral contract analysis.
Yes, my lord, but in our submission, that was an appropriate starting point, and it was an appropriate point to take into account, because this clearly, when one looks at the document, is not a document in which there is a promise and a counter-promise. At most, it can be said that there is a unilateral type contract, or if you will enter into the...
Well, that's the point I'm putting to you.
Yes.
That should have been the framework in which the tribunal looked at this question of direct link and reciprocity. They seem to have been saying that the argument fails because one can't find anything in the contract, i.e. Part 1, which is a stipulation or even a reference to an agreement given by the policyholder to do something. We're not in that territory.
No, which is why if that's where the First Tier Tribunal had stopped, and that's where the Upper Tribunal had stopped, there would be difficulties in defending their reasoning. How in our submission the tribunal had treated it is that they looked at the express terms in that way. They're right that you can't find any direct link based on those terms. They've then gone on to consider the relationship between the first part of the policy booklet and the contract of insurance, both in terms of the relationships between the contract and the relationship between the device service and entering into the contract of insurance. Now, they have dealt with that in terms of applying the VAT direct link reciprocity mutual exchange approach.
Well, can I just ask you about another passage, which again which I don't think we focused on before, at the end of 96. Where starting 4 lines up, we would add that in any event, the issue in relation to the existence of a direct link was not reducible to whether a policyholder wanted or needed a contract with ISL. The question was whether a policyholder was paying for the...
Sorry, my lord, I'm not with you.
My fault. Paragraph 96 on page 1.
Yes, I am on the right paragraph, yes.
4 lines up, towards the end of the line, there's a sentence that starts, we would add...
yes, sorry, I was looking 4 lines down, thank you.
In any event, the issue in relation to the existence of a direct link was not reducible to whether a policyholder wanted or needed a contract with ISL. The question was whether a policyholder was paying for the installation of the device by ISL by entering into Part 1 of the policy booklet. Now, was that the right question? Wasn't the question as to whether the policyholder was paying for the installation by entering into Part 2 of the policy booklet, i.e. the contract of insurance? That's the consideration that was being suggested, and in respect of which the tribunal had to address whether there was or wasn't a direct link.
Yes. I mean, just take your lordship's paragraph 98. The FTT was entitled, in our opinion, the FTT was, in our opinion, entitled to draw the conclusion that in entering into the insurance contract on the terms that the device must be fitted, the person of the policyholder was not to pay consideration to ISL for installation, but rather comply with the requirement of the insurer. So that looks to me as if Part 1 in paragraph 96 is a slip for Part 2, which I hadn't noticed before.
I don't know, because if you go on at 98, the FT was not satisfied that there was a direct link between any policyholder obligations reflected in Part 1, installation of a device by ISL. This is all, one goes back to the beginning of 91. It's all premised on the basis, the argument is that the non-monetary consideration is not only entering into the policy, the insurance contract, but agreeing to device installation and data analysis. And if there is an agreement to device installation and data analysis, that could be found in Part 1 of the policy booklet. It doesn't in terms say, I, the policyholder, you, the policyholder, will agree to allow us to install, and you will allow us to collect data about your driving. But it's implicit in Part 1 that the policyholder will allow ISL to install the box and will allow ISL to collect data. And I think that may be what they had in mind in this passage.
Well, I think your lordship has my answer such as it is to that, which is there's an entitlement on the policyholder to have the device fitted under the policy of insurance, and obligations on him under the policy of insurance to allow the device to be fitted. And in VAT terms, that doesn't, in these circumstances, leave any room for the necessary direct link to be found, one, between entering into the policy of insurance and the device service, or two, the device service and any additional obligations. So the obligations are already owed to the insurer, and in economically realistic terms, the policyholder gives nothing more away.
My recollection is that as a matter of English law, it's no consideration if you promise to do something which you've already promised to do, you're already under an obligation to do to that very person. But it is potentially good consideration if you promise A, that you will do something which you're already obliged to do to B.
This is where I think one, in my respectful submission, why the Upper Tribunal was right to say that one should, at least in this context, of trying to see whether there's a direct link for VAT purposes.
So it's not governed by the same considerations, by the same factors.
It's very hard sometimes not to use consideration in both senses when conceptualising and speaking about this case. But yes, and that's where the significance comes in of looking at the whole scheme of the arrangements. I think you can see, or will perceive, that looking at the whole scheme of the arrangements between all the parties, in particular, the whole scheme of the arrangements between the policyholder, the underwriter and Ingenie, are essential to our approach to and our conclusion on the VAT analysis. And in our submission, starting to ask questions about whether English contract law will recognise as consideration something that has been twice promised to the same person, or something that has been promised to somebody else, can't be the route to resolving things. And yet that perhaps does help our argument to this extent. I think it's perhaps, and you may or may not in the end come out agreeing with this, but it's a crystallized example in this courtroom of an instance where one can see that resorting to the national contract law of a member state, or in our case the UK, can distract you from answering what is the true question, which is going to give you the right answer to the VAT supply for consideration issue. And that's in our submission important to bear in mind, and it's why I'm going to try and go back to where I left off, forgive me, but why the economic analysis cross-check, if I can call it that, if I can label it that, by the Upper Tribunal in paragraph 101 is, if its decision is important, and why we've drawn attention to it. Because we say the policyholder, viewed in an economically realistic way, wants the policy of insurance. Of course, it's a telematics device policy. He's going to have to accept, and does accept in a contract with the insurer, that the device can be installed in his car. And he also knows that he's going to have the device installed in his car because he's contracted with the insurer for that. And we say, as a matter of the VAT analysis, as the Upper Tribunal and the First Tier Tribunal did, he's sort of not interested in the box separately. So when he enters into the contract of insurance, which he knows he's got to pay and does pay, he gets what he needs in terms of the economic reality of this transaction. And there's no necessity to find that he has entered into the contract with the contract of insurance with the underwriter because he's seen, or hasn't seen, but it's part of the contractual documents, the first part of the policy booklet. The economic analysis is that the correct one is that the insured is getting what it wants in terms of the insurance and the device service, concentrating particularly on the device service because that's what matters from the insured's obligation in the insurance contract, and he's paying for it as part of the premium. Well, he's just paying for the insurance. There's no device amount in the premium as we've seen. It's just the
no. But the economic reality, if the policyholder stopped to think, I'm getting this insurance, and it's in order to get this insurance, I've got to have this box fitted, and the policyholder, if they stop to think, would think, well, that's going to cost somebody something, and it's not costing me. And I can be reasonably sure in these commercial arrangements that whoever it is costing isn't going to do it without being remunerated for it in some way. And it must surely be that in some way that remuneration is going to come out of the premium that I'm paying. However it goes round, whoever it goes to, but whoever is doing the installing I happen to know in this case it's Ingenie because they've said they'll do it. I can reasonably infer that although I may not know the amount, Ingenie are going to be compensated for what will undoubtedly be a cost to them if they're installing it out of my premium, won't they? Isn't that how a policyholder would think economically if they stopped to think about it?
Well, with respect, I very much doubt it. I mean, would the policyholder be concerned whether the device was being supplied by the underwriter or somebody else, or by related companies? What the
Well, even if the policyholder thought it was being supplied by the underwriter, they would still think, I'm paying for that out of my premium. That's all going to be taken into account because it's going to be a cost to the insurer.
I can see how your lordship says that, but I suspect that what the typical consumer for insurance is concerned about is the insurance in place so they can drive lawfully, and the premium. So they'll be concerned about how much they're paying. They won't be concerned about how much of what they're paying is going to one cost or another cost of the insurer. And indeed, if the insurer was providing the device in-house, well, that's a little stretch because probably wouldn't be manufacturing it in-house, then it wouldn't be a concern at all. In our submission, that doesn't really impinge on the reality. What the economic reality? The economic reality, in terms of consideration, is that the policyholder knows that they're going to have to pay the premium, and they know as a result of paying the premium, they're going to get the insurance policy, and as part of that, they're going to have the device fitted as an obligation of the underwriter to them. So, in our submission, perhaps respectfully, my lord, that's your lordship's overcomplicating it.
They're just paying a premium for the right to make a claim if they're entitled to.
They're just paying once. What they expect to be doing is just paying once, not to be paying for the device as part of their premium. I mean, they may appreciate that their premium is going to be higher from Ingenie than higher from the underwriter than it might have been because there's a box involved. But actually, I think thinking about it, that's not the way it works, because you buy the insurance because the premium's cheaper, or you hope it's going to be cheaper because your driving is going to be good and stay good, and therefore it's cheaper than going out into the market and getting non-telematics.
But I mean, on any view, this is a special product, isn't it? With the added feature of the telematics and the device having to be fitted and all the rest of it. So, I mean, objectively, any punter who is in the market for this kind of insurance must realise that it has this unusual ingredient, and electronic boxes transmitting data and all the rest of it, like mobile phones you have in your pocket. I mean, these are sophisticated pieces of equipment that need to be manufactured at considerable cost for somebody. But I mean, I take your point. From the point of view of the insured, it's really the amount of the premium that is the bottom line, and that matters. But doesn't that rather support my lord's analysis that you expect it all to come out of the premium objectively, one way or another?
So
there's no other source for the money.
Absolutely, but what one is doing in relation to the device service and all the other aspects of what you're getting from the underwriter is you're paying the premium. And you don't expect to be giving any more.
You certainly don't expect a separate invoice saying to supply of a box, do you?
Well, we've seen in the, I don't suppose I need to open it up again, but part 2 of the policy booklet, 2 places where it says there won't be any extra charge, i.e. extra charge in addition to the premium. We've also seen a table slightly later on where it says the cost of fitting the first device is £0. So
is your case as simple as this, that from the perspective of the policyholder, what they're doing is buying a policy, paying a single fixed amount, which is the premium, and in return getting insurance cover and a box fitted. And as far as the policyholder is concerned, that's the deal, and it's unnecessarily complicated to split that up into different bits. Is that?
I think I can answer that. Well, I'll say yes, that I will answer it in one word. But there are accoutrements, if you like, that go around that, such as we've just been talking of. When you look at the whole of the arrangements, we've got the customer being told that he won't be charged anything extra. We've got clause 0.45 of the Cavia agreement. I don't know if your lordships remember that, which is about any additional cost, fees or remuneration. I think those are the right words.
Yes.
But
Do you agree with Ms McCarthy's interpretation as she ultimately settled on it? That is an agreement.
Well, if I've understood, I'll say what I understand her interpretation to be, which is that means that the underwriter can not be charged anything more in addition to the premium, and that the policyholder can't be charged anything.
It's an undertaking. I understood to say it was an undertaking from ISL to the insurer.
Yes.
That, so far as we're concerned, ISL couldn't charge the policyholder for installing the box.
And that's significant because the way now one has to construe those words. I know one of them is remuneration, but you would think that that would mean that no more consideration should be required of the policyholder by Ingenie in relation to the fitting of the device, and that doesn't fit well with my learned friend's case, that in the whole scheme of the arrangements you have to find some extra consideration passing from the policyholder to Ingenie in return for the device services. And certainly as a matter of VAT analysis and economic reality, it may be as a matter of English contract and implied terms and consumer law that I probably don't have fully in mind, that an English court would be minded to find consideration in a situation like this as a matter of policy I think your lordships will forgive me saying it's a matter of policy, it's a matter of legal policy, in order to ensure that the policyholder has extra protections. But that doesn't mean that it works to convert the fact of entering into the policy into VAT consideration for the supply of the device service, which is the main part of my learned friend's case.
Can I go back to one of the subsidiary ways in which she puts it, which is it's not just entering into the policy, but it's also the policyholder doesn't just pay the premium. He has to do two other things. He has to agree to allow the box to be installed, and he has to agree to allow the data to be collected, both of which require his agreement, because
undoubtedly, my lord, yes.
Yes.
But not his agreement with Ingenie.
Your point is he doesn't need to agree that with ISL. He can agree. No. He agrees that with the.
He's already agreed it, and if you like, it's part of the. It's either part of the consideration that's moving from him along with the premium, or it's just something he has to do in order to receive the service. And although I'm not remaking the argument we made before the Upper Tribunal and withdrew, but in VAT terms, I think when it comes to the reality of the economic reality, one can see there are certain things one has to do to receive the service. You may not want to do them at all. They would have no purpose unless you were receiving the supply of insurance. But nevertheless, you have to agree them with the insurer, so the insurer can provide the sort of insurance that is on offer. So in VAT terms, even if there's some English contract law need to strive for consideration, that there is no need to strive to find consideration moving from the policyholder to Ingenie in return for the device service. And you know, that's why it's important to stress, and we say the tribunal didn't go wrong in stressing, and the Upper Tribunal, sorry, the First Tier Tribunal didn't go wrong in stressing, and the Upper Tribunal was right to find that the First Tier Tribunal hadn't erred. Sorry, I think I've rather lost my thread. Forgive me. Yes, in having regard to the absence of any bilateral contract, any promise or counter-promise, that would have been an easy way to find consideration in English law. Like the Amazon example, it would be very difficult to find why, or to imagine, in my respectful submission, why in that case there wouldn't have been consideration in VAT terms. Just looking, as one shouldn't in VAT terms, just focusing on the one agreement, not looking at the scheme of the arrangements. As soon as one looks at the scheme of the arrangements, the other obligations and the consideration that I've been stressing in the last few moments, the policyholder is giving to the insurer, but there's another side to it as well, which is what consideration the Ingenie is receiving from the underwriter in relation to the services that it's providing under the Cavea agreement. I don't think we need to go back to the Cavea agreement, but it's in particular 4.4, 4.4.1, just about 4.5. But then you go and look at the terms in, I think it's 9 on commission, but you'll see there, and it's transparent as between the underwriter and Ingenie, that the commission amount is being increased by £150, I think it was, in that agreement, if bringing together the parties into the contract of insurance involves fitting, perhaps I shouldn't put it that way, that's for later I think, it involves the fitting of an Ingenie device. So the remuneration for the Ingenie device is coming from the underwriter to Ingenie. It's not as if Ingenie, in economic reality terms, is receiving nothing in respect of the actual installation of the device into the policyholder's car. So just going back to the errors in the Upper Tribunal's judgment that are alleged.
So sorry, can I just?
Yes.
So is the argument this, that first, the distinction that I was drawing between supplying the device service to the policyholder pursuant to an obligation owed to the insurers and supplying the device service to the insurers is a false one, because if you look, for example, at a simple case in which a subcontractor is doing the fitting. Let's look at I can't remember what the name of the subcontractor was in this case, but presumably they are charging ISL under the subcontract, and that is a vatable supply, assuming other conditions, and it's a supply of services to ISL, notwithstanding that they're installing the device in the car of the policyholder. So that if you are supplying a service which involves installing something to a third party pursuant to a contract with someone else, that can be a supply of that service to the person who agrees to pay for it.
Yes.
If that's the right first stage, then you say Ingenie are getting their monetary consideration in the form of the £150 from the insurers as the consideration for the supply of the device service to the insurers, because they're contractually obliged to the insurers to supply it. Therefore, is this the argument, as the Upper Tribunal say at para 101, they can't be both getting that monetary consideration from the insurers and, in addition, some form of non-monetary consideration from the policyholder themselves. Is that the way?
Yes.
Is that the way the argument works?
Yes, the argument does work that way, and I mean, we could see in particular facts where it might break down. If it was some sort of particular personal service, maybe it might be more complicated. But Ingenie aren't going to come out to your... Ingenie don't manufacture the box. They buy the box from somebody else. Ingenie don't come out and install the box. The box is installed in your car pursuant to an obligation on the insurer by Ingenie performing functions it has to perform under the Cavia agreement, and I don't think it subcontracts to ARL, but it subcontracts to a sort of, it's got a recognised installer.
But I only took that as the first stage of the argument to clear my thinking about whether you can supply services to someone to whom you're contractually obliged to perform that service, even if the service is in fact performed to someone else. But the argument doesn't depend upon whether Ingenie fits it itself or gets someone else to fit it. In either case, your argument is it gets its monetary consideration from the insurer, and it is supplying that service to the insurer because it's contractually obliged vis-a-vis the insurer to provide it.
Yes.
The service is provided to the policyholder.
We're not denying that Ingenie in VAT terms also makes supply to the policyholder. I hope that doesn't complicate it, but we say that supply to the policyholder is the no consideration. Because the money is, one can see as a matter of economic reality where the money is coming from. One can see conditions imposed on, promises made to the, in the policy booklet, to the policyholder that he won't have to be charged anything extra.
But that's what that's what I was going to tax you with, because if the position is that you don't challenge that there's a supply to the policyholder as well as to the insurer, and that is pursuant to a legal relationship, leave aside for the moment whether it's contractual, but pursuant to a legal relationship, then it is simply, isn't it, in VAT terms, a completely independent question as to whether there is non-monetary consideration, indeed monetary consideration, for that supply, which can't be affected by whether you're getting some consideration for the supply to the insurers. Whether in accounting terms it has to be taken into effect, no doubt is is a matter of VAT law, which I don't pretend to know anything about. But that's not the question we have to answer, is it? So that the Upper Tribunal paragraph 101 argument, which I was trying to encapsulate by understanding it in my own terms, still butts up against the problem that there is in this case a supply to the policyholder, irrespective of a supply to the insurer. And the question that has to be asked is the consideration in return for which there's a direct link, which is capable of being expressed in a monetary value?
Yes,
which isn't answered by the fact that there may be a monetary value consideration for exactly the same service, which is supplied to the insurers.
Well, it has to be answered in an economically realistic way, and in our submission, the economically realistic answer is clear once you've taken into account that that Ingenie is being remunerated in respect of those actions of installing the device. That's where it's not very helpful to sort of conceptualise it in my submission in terms of two supplies. Is getting its remuneration for that action, and then in our submission there's no need to find, and there is no consideration in relation to the supply by Ingenie to the policyholder. Certainly not for in VAT terms. The economically realistic analysis doesn't leave room for it, and that's what the view the tribunal came to, and which it was entitled to come to.
Well,
First Tier Tribunal on its appreciation of all the contractual arrangements and the facts.
I can understand an argument that the economic reality is that you can't be providing the same supply to two different people. But that economic reality isn't in play,
no.
Because it's accepted that there was a supply to the policyholder. And once one's done that, haven't you just got to look at that supply and see what the economic reality is about that supply?
No, with respect, my lord, then you depart from what's required of you by secret hotels too. It may just be worth going back and looking at it. It's in divider 21, page 49. Paragraph 30.
Yes.
And who supplies what to whom must be who supplies what to whom for what consideration. Must embrace that in our submission clearly. And so that requires looking at the whole of the relationships. So one of the faults of, with respect, my learned friend's analysis is she focuses in on the policy, first part of the policy booklet, and the fact that I realise, my lord, that's not, it's the heart of the case, not all of it. And the fact of the policyholder entering into the contract of insurance. One just doesn't look at the rest. She says one doesn't need to look at it as a matter of English law contract anyway, one's got to, because it says contract at the top, and for the reasons that your lordships have discussed in argument, one has to find consideration as a matter of English law. But then when one broadens out one focus, as the Upper Tribunal and First Tier Tribunal properly did, look at the whole scheme of the arrangements, as you're told to, you have to. And what's said after in Secret Hotel 2 about interpretation of English contracts can't undercut and remove that need to look at the whole scope of the arrangements. One just finds that as a matter of economic reality, the price for the device service is part of the premium that's paid by the underwriter to Ingenie. The policyholder is being told that he's not going to have to pay anything in addition to the premium. There's going to be no further charge, and that you would think means not having to pay anything, not having to provide any other detrimental non-monetary consideration. And as the Upper Tribunal found in paragraph 101, that is an economic analysis which gives the true VAT position. As a matter of economic battle analysis, there's no need to find some promise, something moving as part of a mutual exchange between the policyholder and Ingenie in respect of the installation of the device. It particularly doesn't make sense when the policyholder is being told that there's going to be no extra charge apart from what he pays by way of premium for the first device, and that we haven't really looked much on later events. So I don't think it's necessary to. I think a number of the cases in the first device scenario, he's told that he won't get all his insurance premium back, or there'll be a further charge by way of insurance premium if there has to be a device fitted on certain cancellation events.
Thank you.
I think your lordships have it, so I don't think I need to take too much longer, but we left off at paragraph 91. I think, if I haven't made it clear, I'm accepting that the reasoning in paragraph 91, if it just stopped there, wouldn't be a satisfactory explanation of how the Upper Tribunal came to a right or permissible decision. But then you see the submissions dealt with in terms of in paragraph 93, the inextricable and indissoluble link. And you see the point, which I think does carry great weight in the VAT analysis, and you might think doesn't in English law contractual analysis that are made in paragraph 94. That one can look, the tribunal's not dealing tribunals are not dealing here subjectively, but they're looking objectively to see whether there is mutual exchange. And at 95, could I just ask you to read that, please? And that's covering both elements, of course, entering into the contract of insurance and agreeing to the installation. The reasoning's over the page on 95. And 96 is right in that the tribunal could draw the inference that a direct contract was unnecessary from the perspective of the policyholder in the light of the obligations on the parties in the other contracts. And certainly that was the position in terms of treating entry into the contract of insurance by the policyholder as consideration for the supply of the device service by Ingenie to the policyholder. And again, in our submission, paragraph 98 contains no error of law. And I'm not going to think it's necessary to deal separately with 99, which takes us, I think, to the end of my submissions on the non-monetary consideration point. Perhaps I can just check that I haven't missed anything out with those behind me over the short adjournment.
Yes. Now, how are we doing?
We've
interrupted you quite a lot, but
yes,
we do need to finish this afternoon.
yes. I'll confer with my learned friend, but I can be quick on the other aspects.
Right. 2 o'clock.